Good morning.
Good morning.
As you know, my name is Travis Maddock, and I'm the chair of our commission here. I want to start by thanking you for your interest in your application. If you could start off by giving us a little bit of your background, experience, what qualifies you to hold judicial office. You're obviously a county court judge now, but circuit court.
Sure. So yes, I am currently a county court judge, so I am performing the role in the county jurisdiction, but I have taken some circuit work on. I've had the opportunity to do 5 circuit civil jury trials, a Jimmy Rice trial, some RPOs, Baker Acts. The county judges handle the Baker Acts now. I've also had experience as a judicial law clerk for 3 different federal judges, which has given me great on-the-job training as far as the role of a judge in trial, but also managing a docket, managing the courtroom. So I have the capability to do legal research, to prepare for motion hearings, and to manage a docket.
Okay. Why circuit court?
So as I mentioned, I've had the chance to do some circuit work. So I love being a county judge, and it's a great job. Having the exposure to the circuit level work, I feel that I'm ready for that, and that there was an open position, and if I felt I could do a good job, that I would like the opportunity to do that. So
Okay. Who or what has influenced you to apply for circuit court position?
I would say being able to get that experience, I think we have a great circuit judges here. Judge Case, Judge Nichols, Judge Maltz, Judge Smith. All of them have been great examples for me of being a circuit judge, and I would like to follow in their footsteps.
Okay. What makes someone a good judge?
I'd say being impartial, being prepared, having a good demeanor, being patient, so that you can make sure that all litigants in your courtroom feel like they have the opportunity to be heard and that they will be treated fairly, and that by preparing in advance for cases that you show the litigants and their attorneys that you value their time.
Do you have a judicial philosophy? And if so, what is it?
Yes, my judicial philosophy is to determine what the law is based on the plain language of the text of the statute, and to decide the case based on what's presented to me. So at the trial level, if parties are making arguments when I think maybe other arguments might be better serving them, I'm going to decide the case based on what they've raised and not other issues that are not in front of me.
How do you do that when you get pro ses? I mean, that's always the problem.
So in a small claims trial, it's a little different. So the rules kind of they're not the same as the civil rules. Pro se litigants are still subject to the rules of evidence, but if they have a trial, if it's a civil trial, they can present whatever evidence they want to present, and I would look to one side and say, do you have an objection to that? Usually they'll say, yes, he's lying. And I'll say, okay, well, that's not an objection under the rules of evidence, so if you can tell me why it's not admissible, then I'll consider your objection. A lot of times they don't use the same rules, right? They may say, what does that have to do with it? Okay, that's a relevance objection, and I'll sustain it if it doesn't have anything to do with it. But largely in those kind of cases, it almost goes back to law school problems where you have all the facts presented and nobody's making an argument about what claims they're raising. So I'll hear all of the evidence, and then at the end, I'll be able to say to them, you're asserting a claim for unjust enrichment. Or most of the time, it's a breach of contract case, and say, here are your elements. You have to meet these 3. If you're the plaintiff, you have to prove it by the greater weight of the evidence. So I would explain to them what they had to prove and whether or not they've proved it. So also going back to so that they feel like they've been heard and they understand the ruling better.
As a circuit judge, you may be called to handle felony criminal cases. Let's pretend that this is a felony sentencing hearing in court. As a judge, what factors and or what process would you consider before imposing a sentence?
So in felony, I would look at the sentencing guidelines. I would look at prior criminal history, the nature of the offense, whether there's any victims, what the severity of the injury would be. I think I already said, I didn't say prior criminal history, but I would consider all of those things, plus any mitigation.
What about the death penalty? Do you deal with those of death penalty?
Yes, if it was properly sought and appropriate under the circumstances, I would follow the law.
What do you think would be the biggest challenge for you as a new judge in the circuit court?
I mean, mean, I think if I'm going into an area like family law, I've covered injunctions before, but that's going to be a new area of law. So I would do the same thing that I did when I started on the county bench, and that's to seek out the advice of other judges, to read the rules, to read any CLE materials that I could find on the subject, and also to just prepare. So any proceeding that I'm coming into, I'm going to read all of the filings, read all the cases that are cited in the filings, and make sure that I'm as prepared as possible.
This obviously is going to be a seat in Volusia County. How are you going to handle that daily commute for you?
So when I'm in Ponte Vedra, but when I drove to Jacksonville, it's about an hour commute, so this would be an hour and a half. I recognize it's not ideal, but I think it, is certainly manageable. It's something we considered before I put my name in. Thankfully, I've discovered audiobooks, which make driving kind of pleasant, actually, especially in a quiet car. So I am prepared to do that, and I also think that it's an advantage to be in Volusia, to get to know the lawyers here, to get to know the bar and the community. So I would use that to my advantage.
Tell us about some of the trials you handled
Okay.
as a judge.
So, like I mentioned, I did have 5 circuit civil trials. They were all kind of different. One was the auto negligence case. One was underinsured motorist, whistleblower case. I would say that, they've all raised different challenges and that I've learned something new from every one. Management of the courtroom is really critical when you've got the jurors waiting. You want to make sure they're not sitting for too long. You want to make sure you're able to rule on objections timely. You don't want to have everybody coming to sidebar constantly. But at the same time, you want to make sure that the litigants have the chance to be heard and that everyone's clear when they come to sidebar, they're going back, okay, what questions are you going to ask, and make sure we're moving the trial along.
Do you keep track of the volume? Because county court in a lot of ways is volume. Do you keep track of that and kind of keep metrics for yourself on how you're doing?
So in preparation for this application, I did ask.
And we did not discuss this.
Oh no, I meant in the application you'll see that I put actual
numbers of traffic cases, like 20,000.
I was surprised. Now some of those are probably they're companion with DUI cases, for example, so they get handled on the criminal side. But we do see a lot of them. We get a lot of requests for withhold. So I don't keep track of, okay, today I handled 100 cases, but I did go through the exercise of asking the clerk's office, hey, how many of each type of case have I handled? So I was surprised by some of the numbers.
So family law can be a little bit of volume. What would you do? When you learned anything in the county court that would help you deal with the volume of the family?
So I think we're always striving for more efficiency. So I would try to make sure that I stay on top of the cases. I know in family law cases you have case managers, which I think would be helpful for staying on top of cases. But with the civil cases, for example, we're starting to set everything for case management, calendar deadlines. So for example, if there's been a failure to serve a case and I do an order to show cause and tell me in 10 days why the case shouldn't be dismissed because you didn't serve it, then I'm going to calendar that 10 days. So on day 11, I can look and see, okay, they didn't file anything, and then do the order dismissing it. So basically just actively manage the cases.
How much 20,000, which included the traffic? Do you virtually have to touch each one of those files?
Well, they can, the clerk's office on some of them, if it's a request for withhold, will put together a packet for me. So maybe it'll have 100 cases in it, and I'll pull up the driving transcript, read the citation, and determine whether to grant or withhold adjudication. So it doesn't take very long for every single one of them, but so there could be one like that, or there could be one on a big contested hearing day where I actually have a trial over the citation.
And the 600 small claims, how long do they typically take?
So we get, small claims are set for small claims pretrial, so we usually have somewhere between 40 and 60 on small claims pretrial, so the parties will appear. If they have counsel, they'll usually say it's continued pending settlement because they're able to work it out. If they're pro se versus pro se, we always try to send them to mediation, and I try to tell them, the mediator is a neutral third party that can point out the strengths and weaknesses of your case, and if you come back to court, you're going to be subject to the rules of evidence. And so a lot of times they'll resolve at mediation. We go ahead and set the trial date, so that way they have a date set, so if they don't work it out in mediation, they don't have to come back for another pretrial or anything like that. And I think that helps them work it out. So all of those, to answer your question, don't end up in a full trial, but you see all of them.
What is the biggest difference in the, obviously, the money is different, the sentencing can be more severe. But what is the biggest difference that you saw when you were trying some circuit civil cases?
So I would say the motion practice leading up to trial, the motions in limine, and just, I mean, the actual trial itself isn't that different, right? But what you get leading up to it is more involved in the circuit.
Following up on that real quick, obviously you have a background in federal court working for Judge Howard for so long, so you're used to seeing things decided on the papers. What is, with the changes in the civil rules that have occurred, and it can move up to circuit court, obviously, depending on where you are, there's a chance of much more complicated and complex legal issues popping up. What is your philosophy and feelings on, deciding matters on the papers with our current environment?
Right, well, I think the way that the original rule, the summary judgment rule is written, it tied the response to the hearing date, so, and I think the way that it's written now, I haven't, discussed this, but I think a hearing would still be required for summary judgment, so I would anticipate that we're still going to have those hearings, but at least now the responses have to be, I think it's a great change that the response is tied to the service of the motion instead of the hearing date. But I would rely on, template orders to try to make sure that I'll already have the standards set out to make sure to move those cases quickly and be prepared.
Other than the civil circuit jury trials, have you had any county court trials?
On the civil side?
Any criminal?
Oh, yes, I've had 6. So I actually just had another DUI trial last Monday, so I'm at 12 now.
Okay.
So 6.
Does anyone have any other questions? In closing, is there anything you want to highlight or say before we deliberate?
I just want to say thank you all very much for your time and consideration, and if I'm, fortunate enough to get this position, that I would still continue to serve in the way that I have been and give it the best effort.
All right. Thank you.
Thank you.